The Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. And go ahead and please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Vermont Human Rights Commission versus Town of St. Johnsbury. Case number 23 AP 394. Representing the appellant, Vermont Human Rights Commission, is Mitchell Rotbert. Seated at council table with Attorney Rotbert is Big Hartman. Representing the appellee, Town of St. Johnsbury, is John Klesch.
Thanks very much. Before we get started, we've had WASPs in this courtroom over the last couple of days. So far this morning, you're the second hearing, no problem. And BGS was in here last night and in theory addressed the issue. But let me just say, if either of you, when you're arguing or at any other time during the hearing, if you've got a WASP in front of you, if you've got a problem with that in any way, we'll take a recess and get rid of it somehow. We're not handing out fly swatter with this hearing, although we considered that. They're fairly docile at this time of year anyway. So, but it can be a serious problem for some people. I want to make sure you understand we're willing to accommodate the situation. So, having said that, counsel, if you would come on, please introduce yourself and identify your client and then proceed.
Thank you, Your Honor. Good morning. My name is Mitchell Rotbert, Senior Counsel to the Vermont Human Rights Commission. With me at counsel's table is the Commission's Executive Director, Big Hartman. We represent the state of Vermont in connection with the enforcement of the Vermont Fair Housing and Public Accommodations Act.
Thank you.
May it please the court. Jurisdiction is a creation of statute, not of common law, not created by or can be withdrawn by the conduct of parties in any particular dispute. In this case, the Human Rights Commission commenced an enforcement action by its mandate to see that the Act, Vermont Fair Housing and Public Accommodations Act, was properly enforced in connection with a hearing that occurred in the town of St. Johnsbury by its Development Review Board. In that case, the boyfriend of a woman who resided in a home in St. Johnsbury sought a reasonable accommodation for a person with disabilities. And the town of St. Johnsbury's DRB denied.
And it denied it without commenting at all on Title IX.
That's right.
Yeah.
That's correct. And the Human Rights Commission then commenced what it usually commences, an investigation into what happened in front of the town, including events leading up to the hearing before the DRB, the hearing of the DRB, all of that within the jurisdiction of the Human Rights Commission, and then commenced an action in the civil division of the Superior Court. Why the civil division? Because that is precisely where we, the Commission, must commence all of its actions consistent with 4 VSA Section 31.
Yeah, but no appeal was taken from the decision of the DRB. Why was no appeal taken?
No appeal was required to be taken by the parties thereto.
Why not?
Because none of the parties thereto constitute an interested person within the meaning of the Vermont Planning and Development and Planning.
Well, you argue in one of your briefs, excuse me, I don't remember if it's the reply brief, but you argue that it's possible Ms. Stone qualifies as an interested party.
I think, Your Honor, that is an argument that the town made. There's nothing in this record to suggest that Ms. Stone is an interested person within the meaning of the Vermont Planning and Development Act. That is a very limited definition for under that act. It applies only to persons who own title, who are agreed by a bylaw, or to owners, landowners who own an adjacent property. It doesn't apply to Ms. Stone, and nothing in the pleading. Remember, we're before you on the motion to dismiss an initial complaint in the 12B, Vermont Rules of Civil Procedure 12B. There's no record anywhere, as pled or anywhere else, that Ms. Stone constitutes an interested person, or for that matter, that Mr. Chase, who appeared to argue her cause on her behalf as her mother's boyfriend, is an interested person.
Did the trial court here decide the issue of interested party?
Implicitly, yes, but explicitly, no. And that's the fatal flaw in the ruling below. One cannot attach preclusion principles under the Vermont Planning and Development Act without first determining that there is an interested person who is required to take an appeal from an adverse ruling of a DRB, as here. That was never determined. Instead, the ruling below assumes that Ms. Stone was an interested person. But all of that is kind of onto the side, I submit.
Well, that
Technically separate action.
It
has
ours-
nothing to do with the zoning.
That's correct, because the commission is the sole body that enforces our act, the Public Accommodations Act, for the benefit of everyone.
did you preserve this issue of interested party before the trial court?
The human right only by.
I looked at your memorandum in opposition to the motion to dismiss. I don't see it anywhere in there.
I think that question was not argued to the court below.
Well, no,
Not-
the town in its motion, I think, does make reference to it, but there's no reference at all. Your argument, as I understood it, when I looked at the record, against the motion to dismiss was solely under Title IX. You made no reference to Title 24, I think it is.
Yeah, Chief Justice Reiber, I think that argument encompasses, albeit not directly, the argument that we're making here about interested person.
Implicit, again,
Yes,
implicit.
but I would submit, Your Honor, that it's not, the commission was not required to have preserved it because this motion was under 12B1. Had this been a motion under 12B6 or a motion for summary judgment,
Boy,
we would be talking different.
you know, to be true, I think he treated it as a 12B6 motion. He really didn't treat it as a 12. He said there's no, I forget exactly the word he used, but he said there's basically no way I can provide any relief here, something like that.
The entirety of the opinion below, and it's a detailed explication of what the trial court was thinking, is about jurisdiction. Nothing about the motion put the commission on notice that there was even in the wings some degree of decision on the merits. The trial court below determined that it could not reach the merits because of a jurisdictional bar, and that is wrong as a matter of law. But even if there's something to be said about the commission's argument below, this is still an argument about jurisdiction. As I said at the outset, there's plenty of case law, including under the Vermont Rules of Civil Procedure and its federal counterpart, that 12B1 arguments, jurisdictional arguments, can't be waived. Essentially, parties by their conduct cannot create jurisdiction, nor can they waive their right to jurisdiction or the absence of jurisdiction. And it's essentially the essence of the town's argument to you here is that the issue of preclusion principles should be adopted also to create jurisdiction or the absence of jurisdiction.
Well, you know, it's not, I mean, I think the preclusion is, I suppose, one way to look at it, but finality is what the legislature has made, such a point of.
It has.
In bringing land use issues to a point of conclusion. And this has been a policy choice that I think, nobody in this room is going to be able to quarrel with. It's very clear in the law.
That finality that's written into 24 BSA 4472 is very capped to finality as to interested person.
Well, it talks about collateral attacks even.
The act doesn't talk about collateral attacks. The town is talking about collateral attacks.
Oh, it's in the statute.
Well, it does say, I'm sorry, Brian, forgive me. It doesn't use those words, but
Yeah.
essentially it says, but even then, the finality is only as to interested person. No interested person may bring any subsequent act. But as Justice Johnson has pointed out, we are not that person. The commission is not that person. The commission is seeking an enforcement action for which there is no jurisdiction in the environmental division of the Superior Court. Zero. That the environmental division jurisdiction is strictly limited to appeals under Chapter 24, not to any kind of original action. We, under Title IX, we must bring our action, as we did in the civil division, and that creates the jurisdiction. The basis for the dismissal was the absence of jurisdiction, which is error as a matter of law. It need not have been preserved by the commission because the commission is essentially arguing on behalf of the people of the state of Vermont for all kinds of benefits that don't necessarily have anything to do with the benefits attached to Ms. Stone, any benefit that might accrue to Ms. Stone.
So in your prayer for relief, were you attacking the finality of the zoning board decision?
So, Your Honor, we do. And because we can, we attack the decision, not in that regard.
But you don't have if you win your case in the Superior Court, you don't have any, you can't undo that decision.
I would
Can't
submit,
have that, can it?
I think that it can, Your Honor, and let me tell you how. Our act allows us to review the decisions of any person that is in violation of the Public Accommodations Act. That kind of a person includes a municipality, including in this case, its Development Review Board. And if we conclude, we put on a case, we do discovery, and we put on a case that says that there was something wrong, fatally wrong, in which the DRB arrived at its decision,
Yeah.
violating the act.
I understand that, but your relief is not going to be an order that undoes that final judgment of the zoning board, right? It's going to be other relief.
It can be other, most of the relief will be other relief, indeed. But our authority is to seek injunctive relief as well. And we can seek an injunction to require, say, as was done in the Union Bank case, albeit heard by the Environmental Division, cited by the town, to go back and review what you did. That is certainly part of the relief that we can seek in this case. And that is because we really do have separate columns of review here. It's the Environmental Division is reviewing decisions by the DRB where interested persons raise the question. That's the finality box that was created by the legislature. And the Human Rights Commission stands completely outside that box. The commission will never be an interested person ever. I mean, the only context I can think of is human rights one day owns a building and somehow is involved in a zoning dispute. But then we're in our own.
Or inhibited. I think the town is arguing somehow you're inhibited.
Thank you, Your Honor. I think the town is our privity, and that's why I submit to you that the town is trying to create or show the absence of jurisdiction through preclusion principles, which is, I think, forbidden. It's just jurisdiction is statutory. But the commission is not in privity with Nicole Stone. The commission cannot be in privity with Nicole Stone because the bundle of rights that the commission has to enforce are not anywhere near what any particular aggrieved individual, using the term in our statute, we're never in privity. Now, there may be situations where there would be something that an aggrieved individual did, like maybe settle a case that would have some bearing on the kind of relief that that aggrieved individual might be able to receive in connection with the commission's enforcement action. But it doesn't jurisdictionally bar the commission from seeking the relief on behalf of the people of the state of Vermont.
So what's the mandate you want here? What exactly is it you want this court to say?
I would thank you, Your Honor. I think this case should be, the decision of the trial court should be vacated. The case should be remanded for purposes of developing a record, whether it be for purposes of trial or if the town seeks so inclined on summary judgment on the questions presented, because the questions presented by the town go to the merits. If there is going to be an argument about preclusion principles, as Justice Johnson raises, those are questions that are properly raised on the merits below, not as a basis of jurisdiction. This decision is incompatible. The decision below is incompatible with 4 VSA 31 and 34, and we need not worry about any other question at this time.
So go back to the merits, to the civil division, and have the civil division decide the merits of the request from your agency.
So, well, essentially, if Justice Comm'n, if I could have everything, I'd want to basically have this court determine the commission has the right to proceed in its enforcement action, because that's precisely what our.
Right, but what is it
requires.
that you want beyond that? You want an order that says this gazebo or whatever the structure is okay?
Ultimately, we want an order that allows us to enforce the Public Accommodations Act against the town in connection with this decision, denying a reasonable accommodation to Nicole Stone. That is a tribal question in the civil division. It's not barred.
So you want an order essentially that reverses the DRB decision, right?
Ultimately, that's one of the forms of relief that the commission will seek, but it may not seek it in that context, Your Honor. I can envision seeking an order that requires the Environmental Review Board to create a record about what it did and why. I don't think we have that, and we don't have it in this case. We don't have it on this. Definitely, we don't have it on the Rule 12B1.
Your light is on and your time has expired, so thank you very much. We'll hear from counsel for the appellee, please. Come on up and for the record, identify yourself and your client if you would.
Good morning, Your Honors. May it please the court. My name is John Klesch, and I represent the town of Johnsbury in the matter before you.
Thank you.
The question of jurisdiction here is primary. I agree with that. But the question is, who has jurisdiction to review a decision of a development review board, particularly on a variance application? This court has been very clear on that subject. In Gold versus Town of Moncton, 2016, Vermont 84, the court reviewed Title IV and noted that 4 VSA 34 states an exception to the civil division's general and exclusive jurisdiction. Specifically, the court said it grants jurisdiction over matters arising under 24 VSA Chapter 117 to the Environmental Division. Chapter 117, of course, is the land use statutory regime, which includes variances.
So wouldn't that involve Ms. Stone's issue regarding getting the variance from the town and not the commission's? So you've got two different things. You've got Ms. Stone asking for a variance, and she goes through the process of getting the variance, and you got the commission saying you need to enforce the access issues that are required by the state of Vermont. So they're really two separate issues or two separate claims. They may be connected in some way, but the avenues in which you go through that are separate, are they not?
They can be, Justice Cohen, but in this case, as Judge Tomasi observed in his decision, is that it is impossible to separate a review of the Development Review Board's decision whether a variance was necessary, which is statutorily prescribed to the DRB and then the Environmental Division, from a question whether Ms. Stone was entitled to a variance.
But why did that throw the Human Rights Commission out of court? They're there on a completely different statute and might be entitled to an array of relief against the town for the consequences of its action.
Justice Johnson, it's not necessarily throwing the HRC out of court. It's the Civil Division recognizing that it does not have authority under the jurisdiction statutes to review whether a DRB erred in
But that's
receiving.
because the court perceived it as a collateral attack on the decision, which it isn't necessarily. It may affect it, as Justice Cohen just said, but their statute is completely separate.
Well, Your Honor, I think there are two related themes here. One is purely jurisdiction under Title IV. And I think we can all agree, Civil Division has no jurisdiction to review matters under 24, under Chapter 117. And by the way, let's remember that the zoning statutes do say that all zoning bylaws must be read as incorporating and not violating fair housing principles. That's the point of the Union Bank case, that the Environmental Division does have authority to enforce the Fair Housing Public Accommodations Act. And then this court would have the opportunity to review the decision from the Environmental Division. But then the finality principles of 4472, okay? This court has said over and over again that there cannot be any kind of collateral attack on an unappealed decision from a municipal panel. And for the Civil Division here to say, we're going to ignore the fact that there was a decision in the DRB that was not taken up through the appeal channels under 4469, under the Chapter 117, and say the Civil Division will decide that whether or not a variance should have been granted. The variance criteria, which are prescribed in Chapter 117 for the DRB, for the Environmental Division to review, we'll put that aside. We'll make our own decision in the Civil Division.
My problem with this is that the issue in the discrimination case is whether they intentionally discriminated against her.
That's not the issue, Your Honor. That's not the claim. The claim is whether they failed to make a reasonable
Well,
accommodation.
or failed to make, well, that's the same thing. Failed to make a reasonable accommodation to her disability. That's discrimination, okay? So that's the issue in that case. It's a totally different issue from whether or not they were going to grant it, okay? It's a different issue.
Well, Your Honor, if you look at the criteria that they say are required to be established for a claim under the Fair Housing Public Accommodations Act, they list in their trial court briefing the 5 elements. One of the elements is that the requested accommodation may be necessary to afford Ms. Stone an equal opportunity to use and enjoy her dwelling. That's what a variance application is all about too. Whether an exception to the zoning bylaw must be made in order to permit a reasonable use of property.
So, Mr. Cleach, I'm just going to take a different lens to this and just say, looking at remedies, the remedy that's available to Ms. Stone directly going through zoning and then to the environmental court is different than the remedy the commission would have by going through the Civil Division. It might end up being the same thing, but the request for relief is different. And the findings would be different as to which, whether or not this is a discriminatory act or not a discriminatory act, or whether or not it fits within the criteria of the town's zoning regulations as a variance.
Justice Cohen, we believe that the best way to try to resolve what looks to us to be competing interests here in the law is that a party to, or an interested person who is seeking a variance under and supported by the Fair Housing Public Accommodations Act, in other words, asking a DRB or asking a court to modify zoning regs, for example, the wheelchair ramp that couldn't meet setbacks in the Union Bank case. If they succeed on overturning a DRB decision, then a court with authority under Title IV to review those kinds of decisions will have found that it was an error for a DRB not to have accommodated that person. In that case, that would make out the fourth element of a fair housing accommodation claim. And then the HRC or the aggrieved individual, if they think there's some damages they wish to pursue, if they think there's some injunction they need to pursue, so be it. But that would avoid the problem of the the civil division sitting in the shoes of the environmental division and deciding a variance.
But are you saying that there is relief available to the HRC that does not involve tipping over the DRB decision?
Not in this case, Justice Eaton, because again, the civil division does not have jurisdiction to review whether the DRB got it right or wrong. In a case where a DRB decision was properly appealed up the chain through the environmental division and here possibly, then yes, it could be the case that the HRC, because obviously there's no monetary damages in the environmental division. The environmental division simply stands in the shoes de novo of the DRB and decides whether to issue a permit or not.
But doesn't that preclude the commission from, the Human Rights Commission from having any access to a remedy under that analysis?
Under the facts presented here, yes. Under different facts, no.
And what would those different facts be?
Well, so specifically in the context of a municipal panel decision is what you're interested in?
Or any situation where you have the conflict between, that we're faced with in this case?
Well,
Or do you skip that question? You can move on to the question.
Sorry. Another point to make is that the town does not quarrel with the importance of the HRC's mission to prevent discrimination, including in housing. Under the facts here, there would have been a path forward, which is that Mr. Chase, Ms. Stone could have appealed to the environmental division. I see nothing in the statutory mandate for HRC that would have prevented HRC from not representing those folks at the environmental division, of course. But if you look on the HRC's website, it talks about its mission is for public education and outreach. And it seems to me there's nothing that could have prevented HRC from being a resource to those folks if they wish to pursue an appeal. There's also nothing preventing those folks from pursuing a new application that addresses the issues under the successive application doctrine. They can still apply for this structure.
The commission could assist, but certainly wouldn't have standing in the environmental court.
I agree with that, yes.
Okay, but they could help.
I'm sorry?
They could help. They could.
I see nothing in their statutory mandate that prevents them. It talks about public education and outreach and that people contact the HRC with questions about housing discrimination. So I'm not sure why, instead of litigating this case against the town for the DRB's quasi-judicial activity and finding that the application did not meet the criteria requiring an accommodation, why the HRC could not have pursued another avenue. And in fact, the HRC criticizes the town in its briefing for not instructing the applicants about going about filing a second application. The HRC could be doing that right now. I do want to mention quickly the question about who is or is not an interested person. I think I heard counsel say that even the owner applicant for a permit is not bound by a DRB, an unappealed DRB decision. And of course, I don't think that's consistent with the precedents. The statutes have been interpreted so that both owners and occupants of properties which are subject of a permit application have been held to be bound under 24 VSA 4472.
So the definition of interested party, which I thought he was right about, includes owners of property. There's case law that occupants as well.
Yes, Justice Robert, we cited that in our brief. I don't have the site at my fingertips.
But it's in your brief. Okay.
It's in our brief.
Yes,
sir.
All right.
There's also this question about whether there was waiver, whether facts should have been developed on the record. Respectfully, I don't think the HRC is getting the rule quite right here in its presentation. This is not a matter of whether the civil division improperly found that it had jurisdiction over something. This is a case where the civil division refrained from exercising jurisdiction, determined it did not have jurisdiction. And this court in, I believe it's State versus Therian, said that the kinds of considerations that apply and maybe preclude waiver when you fail to preserve an argument at the civil division don't apply in a case where there is improper exercise of jurisdiction. Here we have the reverse scenario. And in fact, in the Therian case, the court said exactly that, and we cite that in our brief as well. The other thing I wanted to mention is while the town respects and agrees with the weighty mission of the HRC and the importance of the Fair Housing Public Accommodations Act, but we also should not lose sight of the weighty policy considerations in Chapter 117 that regard interested persons. At the DRB, the neighbor, who is the person affected by this structure, okay? The structure is built into a setback and encroaching into the setback that is the neighboring yard. She came before the DRB and stated her concerns about why the structure was a problem. And if the civil division were allowed to simply say, we're going to forget about everything that happened at the DRB, we're going to forget about whether the environmental division did anything, and we're going to decide, here's an injunction, Ms. Stone, HRC, the structure gets to stay, that person has been completely cut out of the process that the legislature has set up for review of those kinds of situations. Much better off going up to the environmental division, where Judge Durkin and Judge Judge Walsh, thank you, are very familiar with bringing neighbors and property owners and municipalities in and listening to competing considerations and resolving them in a way that sometimes results in a variance, but a variance that meets the statutory criteria, which is the minimum impact necessary, does not cause an affront to the zoning system. All of those kinds of considerations are nothing that the civil division would have before it when it, as HRC asks, would be sitting in review of a DRB decision on a variance. Thank you very much.
Okay, thank you very much. Does the appellant have any time?
No, the appellant has no time.
All right, thank you. Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 10:45 this morning.